So imagine this. Your loved one comes back from an appointment with the healthcare provider and something just wasn't right. Maybe they were prescribed too many pills in too short of a time. Or maybe the provider started asking inappropriate questions during the exam. Or you noticed they were being billed for equipment or services they never received. What would you do in this situation? Call the police? Contact the provider's office? Today we'll explain to you how anyone can file a complaint with the medical board and what happens to that complaint once it's reviewed by board staff. Listen in. You're listening to MedBoard Pulse, a podcast by the State Medical Board of Ohio. I'm your host, Jerica Stewart, Communications Director. Let's talk, Ohio. Welcome back. You're listening to the second episode of MedBoard Pulse, and as promised, today we're going to explore the ins and outs of the board's complaint and investigative process and what happens when the board disciplines a provider. Joining me today is James Roach from our enforcement unit. Welcome and thank you so much for being here, James.
Glad to be here.
I have some questions for you today on how the board works and the way that the complaints are processed here at the medical board. So first of all, can you please introduce yourself officially and describe your role at the medical board?
Sure, I'd be glad to. So my name is James Roach. I am an enforcement attorney for the State Medical Board of Ohio. I have been an enforcement attorney here at the medical board for 10 years. And essentially my role at the medical board is that after a complaint has been investigated, it will come to me or one of my colleagues who are also enforcement attorneys to essentially review the case and determine what should happen next as far as the complaint in the process.
I'm sure listeners are familiar with the word complaint. You know, the kids complain or, you complain about, a poor customer service experience, at a restaurant or something like that. But what are we really asking for when we are asking patients to file a complaint officially?
Sure. What we're asking for is essentially anyone who has a reason to believe that a licensee of the medical board has violated one of our statutes, one of our rules, anything like that. So certainly we don't expect complainants to have to know every single violation that we have or anything like that. But if you have reason to believe that there has been something that's gone wrong, please notify us of the board and we will examine that particular matter. And in talking about this, we certainly understand that there will be a variety of people who have information, and sometimes that information is not firsthand knowledge about a particular situation. Maybe it's a neighbor who said, I had this bad experience happen, or maybe it's a child or a parent who's also had a bad situation. Sometimes you hear the word hearsay thrown around, and can I file a complaint if I don't personally have knowledge about what happened or I wasn't in the room? And the answer is yes. If you have reason to believe that a licensee of the medical board has done something wrong, please file a complaint with the board.
Awesome. That makes a lot of sense. And I think that also helps to clarify that it's not just being unhappy about, a poor experience. Like I didn't like the way that I was treated per se, or I didn't like the personality of that person. But there's really an issue going on that the board should look into that is an unprofessional issue or an issue with the care that was received. So I think that's helpful to understand as a patient. But not all complaints actually end in disciplinary action. Is that right?
That is correct. The board receives all kinds of different complaints, but not every complaint that we receive is something that falls within our ability to act, or essentially the jurisdiction that has been granted to us under the law. So to give you some examples, sometimes we receive complaints against non-licensees, such as office managers or office staff. Those are not complaints that we have the ability to take action on. Another common complaint that we sometimes receive at the board is billing complaints. And billing complaints might be a variety of different matters, but essentially what I'm thinking of are situations where a patient or client is dissatisfied with a bill they have received, maybe it came from an insurance company or a hospital system, things of that nature. We cannot take action based on that. When we do receive a complaint that is something that is within our jurisdiction, what we are looking at is essentially to determine what is necessary to protect the public and what is most fair to the licensee. So certainly we receive some complaints that are of a more serious nature, and in those situations we are looking to take a public disciplinary action. But there are other times where there might be another path that might be available to us to address those particular concerns. For example, sometimes a licensee may just not be knowledgeable about a change in one of our rules, or one of our laws, so we can have a conversation with that licensee, perhaps make a recommendation as it relates to education, some sort of course they can take to fill in that gap in their knowledge, or perhaps we have some information that we can provide them. The goal there is to correct the behavior, correct it as quickly as possible, and still protect the public. And so by doing this in a more informal way that allows us to help the practitioner to practice more consistent with standard of care, it also allows that practitioner to continue to practice and be able to serve their community.
Do complainants know when a complaint is closed in that way, and if it's not going to go forward for disciplinary action?
Yes, they do. So whenever we receive a complaint, and that complaint ultimately ends in some sort of close, the complainant is notified by a letter letting them know of that outcome. We certainly encourage anyone who files a complaint to provide an email address, because that is our preferred manner to notify complainants about when a complaint is closed. And when you receive that letter, just to give you a preview of what will be in that letter, if there's no action taken, the letter will inform you of that. But please keep in mind that just because we haven't taken disciplinary action, as I previously stated, that doesn't mean nothing happened. It doesn't necessarily mean that we don't believe you. In fact, it could be the complete opposite. It just means that after the board has reviewed the matter and taken steps to look into the matter and address the matter has now been closed, and there just doesn't happen to be public disciplinary action attached to that.
I'm glad you mentioned that. I think we've heard sometimes from patients they're concerned if they're the only person who complains, they may not be believed, and that the board requires additional, like messages or complaints filed about a particular issue for them to be taken seriously. But that's not necessarily the case, is it?
No, not at all. There are many times that we receive a complaint from one particular individual, and from that, essentially the situation snowballs, and we find out about other people who have had similar experience. It's also true that maybe you are the only person who's had this particular situation happen to them, but there may have been a complaint, say, 6 months ago that was of a similar nature. So we certainly would encourage everyone who has information about some sort of violation of our rules and laws to file that complaint. Let us know, and let us look into it just to see if there's anything more there.
That's really helpful for people to understand. Filing a complaint gives us the opportunity to really investigate. So you don't have to vet it out in your own mind. We want to be able to look into it and figure out, if this is something that is a patient concern or a safety concern. So thank you for clarifying that, James. So I am curious. So there are times when complaints get closed and times when maybe a provider needs additional education or information in order to practice to meet that proper standard of care. But if the investigation does prove that action does need to take place, what happens to that complaint after it's filed and it decides to move forward in the process?
Good question. So there are a couple of different stages to any complaint that is received by the medical board. When the complaint is first received by the medical board, the first thing that happens is essentially a short review of the information to make sure that this is something that falls within the jurisdiction of the medical board. So essentially something that we have the legal right to actually investigate. Once that determination has been made, that involves one of our licensees, that there is an actual violation, then it is investigated. And it can be investigated in a couple of different ways. Certainly, I think when people think about investigations, they think about an investigator coming out and talking to witnesses and uncovering evidence and things like that. And certainly that happens sometimes. But when we're talking about the practice of medicine specifically, sometimes that investigation can look a lot more like obtaining patient records, going through those patient records, talking to doctor experts to look at what kind of medical care was provided and was there any deviation from that. So they can take a number of different paths as it relates to that investigation. And then once that investigation has been completed, that's when it comes to someone in enforcement like me. And what we are essentially doing is we are looking at all the information that's been collected, and we are making recommendations to the board as far as what should happen as far as next steps go. And sometimes that could be public action. It could also be some of these remedial actions, whether it's an education course, perhaps it was just the talking to the doctor and explaining to them where they did wrong, or maybe there just isn't enough evidence at that point in time to move forward. And so we make that recommendation, and then the board members decide what will happen next. If the board members decide that there is a public action or public discipline is necessary, that's when we get into this more the administrative hearing, which is kind of like a trial and some sort of public action by the board.
Wow. And when I think about the kinds of cases that I've seen come before the board, sometimes they're really sensitive in nature. We have prescribing issues, we have some sexual misconduct concerns. There could be just minimal standards where maybe that provider wasn't using the proper skills to be able to treat that patient. So it sounds like sometimes these issues are sensitive in nature. Throughout this whole process, is a complainant required to provide their name publicly? And does the board have to recognize that they are the person who actually filed that complaint against this provider?
So no, you do not have to provide your name when you file a complaint. Now, that being said, you have to understand that if you do not provide your name or if you do not provide personal information, it could be very difficult for us to investigate. So if we receive a complaint that says a doctor did a surgery wrong, but we do not have the name of the patient that was involved, we do not have your information as a complainant, unfortunately, there's not going to be a lot that we can do to fully investigate and vet those concerns. So if the complainant is comfortable, we certainly encourage the complainant to provide contact information so we can be in touch with them, find out what information they have, and proceed from there. Now, in doing so, we understand that it's not always easy to come forward with a complaint. And sometimes, again, you might not know for sure what has happened. You've heard things, or you're aware of these things from a close family or friend, things like that. And so I understand there can be some hesitancy about, well, is this something I should report? Is this going to be held against me if it's proven not to be true? What I would say about that is that all complaints are confidential, including the identity of the complainant. So that will never come out. I would also say that if you provide your information, we will make every effort to contact you to try to find out what kind of information you have. And then even if this then leads to some sort of public disciplinary action, we are always trying to maintain confidentiality, especially when we're talking about sensitive medical information. And so that can take various paths to try to protect your information, to make sure that the only thing that is made public are things that are absolutely necessary. So if there are, sensitive medical issues that you have dealt with, you are referred to by your initials to try to protect your identity, or we'll give you a patient number instead of your personal identity. Again, our goal is to address the issues that are alleged in the complaint, and that doesn't necessarily require making the identity of the complainant public.
That even applies then to when a case is actually fully disciplined and someone, licensee, comes before the board and action is taken. Even after the whole complaint is resolved, the confidentiality still remains for that patient?
That is absolutely true.
I think that's really important for people to understand when they're coming forward. We want to make sure that they are confident in that process. We're going to take a short break and hear from another member of the medical board team, and then we'll continue our conversation with James Roach. In this part of the show, I want to introduce you to an important member of the board senior staff, our medical director, Dr. James O'Neill. In upcoming episodes, you'll be hearing from Dr. O'Neill on a regular basis in our Medical Minute segment. Dr. O'Neill, thank you for joining us.
Jerica, thank you for having me. It's a pleasure to be on your podcast today.
I think listeners would appreciate hearing some of your background information as a physician. Let's start first with where you studied medicine.
To answer your first question, I graduated from the Jones C. Edwards School of Medicine at Marshall University, and I'm a general internist. General internists typically see patients in the hospital and in the outpatient setting. I started my career as a hospitalist and a teaching service, and then moved to the outpatient arena.
What is your role here at the medical board as the medical director?
As the medical director for the board, I work with the quality intervention team. The quality intervention team's primary focus is to assure that the public is receiving standard of care. We also make sure that impaired physicians are treated fairly through our compliance program, and we have a close contact with the Ohio Professionals Health Program, which monitors our impaired physicians.
Why is the role of the medical board important?
The medical board's mission is to protect and enhance the health and safety of the public. We do this through effective medical regulation. In other words, protecting the public, but treating our licensees fairly.
What kind of information will we get to hear from you in future episodes in a Medical Minute?
In future episodes, I will discuss common medical conditions, self-care, and treatment, such as our common colds, allergy symptoms, diabetes, hypertension, and so forth. These will be short, brief, and essentially provide the public with self-care tips and when to see the doc.
I know we are excited to see you serve in this role as the first medical director here at the medical board. What are you excited about, both in this podcast, but also in your role and moving forward here?
I'm excited to be with the medical board because it is an evolution of what I've done for the past 20 years. I started out in the teaching role. I did private practice in both the hospital and outpatient setting. And now I want to share with the other members of the team my clinical knowledge and help them to discern minimal standard of care.
Well, Dr. O'Neill, we appreciate you spending time with us today and look forward to hearing more from you in our upcoming episodes. After a brief break, we're going to be jumping right back into our conversation with Enforcement Attorney James Roach and taking a close look at what happens when the board does decide to discipline a licensee for a violation of Ohio rule or law. I hope you continue with us.
Of the many medical professionals working across the state, the medical board regulates roughly 98,000 individuals. Those professions include physicians, physician assistants, massage therapists, radiologist assistants, respiratory care professionals, anesthesiologist assistants, genetic counselors, acupuncturists, and dietitians. For more information on our licensees, please visit med.ohio.gov.
We're back from our Medical Minute break with Dr. O'Neill to hear from James Roach and to really understand the disciplinary process and what kinds of discipline the board has the authority to issue against a licensee and really what these different terms mean. I think sometimes patients can see these terms thrown around if they're going to look up a provider on e-license or they maybe hear that someone has been disciplined, but there's a lot of terms used by the medical board and I want to make sure those are clear to patients today. So my first question for you, James, is what kind of discipline can the board actually issue?
When it comes to public discipline, the board can take several different actions. One example is a reprimand. A reprimand is really just a fancy word for a public letter, essentially telling the licensee what they've done wrong. More serious than that is sometimes a suspension, and sometimes suspensions can be as short as, say, 30 days, or it can be months or even years. And the idea with the suspension is to take the licensee out of practice and then for certain steps to be put in place that the licensee has to complete before they're allowed to return to practice. And again, the goal here is public safety. Sometimes there is probation. And probation is similar to suspension in the sense that, again, there are a list of things that the medical board is asking of the licensee to do to assure the medical board and the public at large that they are capable of practicing consistent with our standard of care. Sometimes there are revocations. Revocations are essentially revoking the license. So we are an administrative licensing board. At the end of the day, the most that we can do as a licensing board is take someone's license. And so sometimes we take what are known as non-permanent revocations. What that essentially means is that the individual loses their license, but they have the opportunity to come back after a period of time to apply for a new license, or sometimes, if absolutely necessary, there is a permanent revocation. And what that means is that the individual is not eligible to hold any license that is issued by the state medical board.
That definitely seems like I've heard one of our board members say the nuclear option. So if you're permanently revoking someone's license, that means they can never practice in Ohio ever again. Is that right?
That's correct. And it happens immediately at the conclusion of the board meeting. And so the board takes that very seriously. Certainly, we understand that sometimes there are situations where the conduct is just so egregious that there's not a intermediate step the board can do to correct the action. Certainly, when we're talking about situations that result in very serious harm to patients or other members of the public. So the board gives that gives it a lot of consideration before it issues that kind of decision.
Yeah, I can imagine that's definitely a matter of it shouldn't be taken lightly, and I imagine something that is done in order to protect the public, since that's our mission. Thank you for explaining the different types of actions that the board can take, and those are all the final decisions the board makes about a provider's license. I'm curious though, is there any step the board can take in between when they make a final decision? Maybe they're made aware of an issue that is really egregious and they have to follow a formal process. We heard about the hearings and really kind of a formal sequence of events that has to take place. But is it ever possible that some behavior of a provider is so egregious and so dangerous that the board has to do something immediately to intervene?
Yes, that does come up from time to time. This can come up in a couple of different ways. One common way that this comes up is that you have a licensee of the medical board who is convicted of a crime. And obviously, if an individual has gone through the legal processes, the criminal legal processes, they've been found guilty or pled guilty to a serious criminal charge, that is something that under the law, the medical board has the ability to immediately suspend that individual's license, even before the medical board makes a final decision on the case. Other times, maybe it hasn't gone through a criminal case, but it's the type of allegation that raises significant concerns as it relates to public safety. In those particular situations, the medical board does have the ability to issue what's called a summary suspension. And what a summary suspension essentially means is that that individual is not allowed to practice in the area where they are licensed until the medical board has had a hearing and issued a decision. Now, that is obviously a very significant action by the medical board. So when the medical board issues those types of actions, the individual who's accused has the opportunity to ask for what we call an expedited hearing. So they have a right to essentially go to a hearing, have those concerns heard in front of a hearing examiner through the administrative law process very quickly, and then come before the board on a shorter calendar or time frame to make sure that the medical board, when taking action against this individual and taking them out of practice immediately, has done so for legitimate reason, and that the concerns have been proven, and that therefore the suspension should continue.
Sometimes I see also that the board includes something called a consent agreement, or sometimes I see it as a settlement agreement. What is that?
Sometimes it makes more sense if a licensee is willing to resolve things amicably. What I mean is just that there's an agreement from the licensee that perhaps not everything that was done as it should have been, and they are open to resolving the matter in a more voluntary way to resolve those particular concerns. And the medical board is always willing to work with the licensees on those more intermediate violations. If we have someone that is open to remediation or correction, and if it is something that can protect the public. And so when we had those particular situations, we'll certainly talk to the licensee, and if they have an attorney, talk to their attorney. The advantage to the public when we can resolve cases that way is that it's just a much quicker process. So we talked about summary suspensions, and certainly there are times when cases move very quickly, but on a more typical schedule, going through the public disciplinary process can take months, and the public needs to be aware of that. And so sometimes the best action is to address that behavior that needs to be corrected immediately, and get that situation fixed, and then allow that practitioner to return to practice and hopefully learn and improve their practice from that point forward. And that's what consent agreements allow us to do, is essentially it's just an agreement with the licensee to how they are going to correct their conduct or the action, and how the medical board is going to move forward.
That makes a lot of sense. Thank you for explaining that. I know I see this question come up sometimes too. Can the board convict someone of a crime, or send someone to jail for that matter?
The medical board does not have the ability to send anyone to jail or send someone to prison. ability to act is really as it relates to the license. And so, one of the things we sometimes see is that there are conduct that is conducted maybe under guise of medical practice, but they aren't actually a licensee of the medical board. And unfortunately, because the most we can do as medical board is take a license, they don't have a license to take. We're really kind of limited in what we can particularly do. There are situations where the medical board investigates situations that have both a criminal component and also administrative law component. And we are always looking for opportunities to work with law enforcement. And when there is the possibility of jail or criminal charges, the medical board, where appropriate, will step aside to allow law enforcement to do their processes if it allows us to still protect the public. And so certainly we are very respectful of the criminal process, but we do not have the ability to file criminal charges or send someone to jail.
Thank you for making that clear. So this is a lot of information you're providing about discipline, about the severity of discipline that providers can receive. But as a patient, how can I know if my provider was disciplined? Or if I'm looking for a new provider, is there a way for me to find that out, but they have been in trouble with the board in prior years or months?
Yes, I would strongly encourage members of the public to check out the State of Ohio's e-license website. And this is not just for medical board licensees, but it's for a variety of licensees, counselors, psychologists, nurses, things of that nature. All of this information is publicly available on the State of Ohio's e-license website. And what you will find when you do that is that you can do a search and find out licensees. You can find out, as it relates to medical board licensees, if doctors, what medical specialties they may have. You can also find out about whether they have any board discipline and use that information to make a determination as far as who would be best for you as a physician or any other licensee.
Last question for you today, James. What is your favorite part about working for the medical board?
My favorite part about working for the medical board is the opportunity to essentially, I know it sounds corny, but it's make the world a better place. And I mean that quite seriously. We have a big duty here at the medical board. No one has the responsibility like the medical board that entails both protecting the public and then being fair to the licensees. And so as a part of that, we are always looking to enhance the practice of medicine in the state of Ohio. It's something that we're all going to take advantage of at one point or another, often multiple times. And so it only benefits all of us that if all of us have trust that the practitioners that we see are going to be practicing competently, that they are going to be practicing safely, and that we are going to receive the best care that we possibly can. And I'm just appreciative of the opportunity to be a part of that.
We appreciate having you. There is so much, as you said, the board is responsible for, and over the next several months and hopefully years, you're going to get to hear more about that process and even hear about cases and understand the real consequences of the actions that providers take, but also the responsibility of the board to make sure that it's there to protect the public and enforce its rules and laws when necessary. So thank you so much for listening today. And James, thank you again for your time. I think you've made us better and made us smarter. So I appreciate that very much.
Thank you, Jerica.
In our next episode, we'll be discussing ways in which the board investigates allegations of sexual misconduct. It's a sobering topic, but one in which we've learned many lessons over the last several years and want you to be informed too. We hope you'll join us. Thank you for listening to this episode of MedBoard Pulse from the State Medical Board. A special thanks to our guests, James Roach and Dr. James O'Neill. We appreciate your dedication to the safety of Ohio patients. Subscribe today to hear our episodes right away. For more information about the medical board, visit med.ohio.gov. You can also email questions or comments to communications@med.ohio.gov. And remember, the more you listen, the more you'll learn, and the more you'll share.